Welcome, everyone, to another employment law session. My name is Lior Samfiru. Hopefully, you all can see me. And why am I here? Well, hopefully, you know, I'm here for you. I'm here to answer your questions about employment law. Again, I'm Lior Samfiru, the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP. We are the largest employment law firm in this country of ours. And what I like to do every Wednesday at this time to log on here, turn on my camera, and allow you to ask me any question you want about employment law. This is your session. It's for you. It's for your benefit. If you've always wondered about something, if you want to know about whether what your employer is doing is legal, I often get questions. Well, my employer is doing this or saying this to me. Can they do that? Is it legal? Well, you don't need to wonder anymore. You can ask me right now, and I'll tell you if it's legal, if it's not legal. And if it's not legal, I'll tell you what you can do about it. So this is that opportunity that you have to ask that question. Oftentimes I get asked questions from people that have lost their jobs, and they want to know what are they owed as a result of losing their job. Ask that now. People ask me questions about their employer changing their hours or their pay or their job duties. Can they do that? Well, now's the time. Let's talk about that. Ask the question. So if it has to do with your workplace, if it has to do with your employer, I'm here for you at your service answering those questions. So you see that box on the screen, type in the question, hit enter, and I will answer it. Now, before we start answering questions, I've seen there's already a few that have come in. I'm going to start answering them. But before I even start with that, here's some other contact information. Okay, if you want to connect with me and my team, or if you just want to learn a lot more about employment law, here's what you do. You go to employmentlawyer.ca. You see that address on the screen below, employmentlawyer.ca. And when you get there, you'll have my phone number, my email address. You can read a lot about employment law. Use various tools that you have to inform and educate yourself. It's always your first one-stop shop for everything employment law. Again, employmentlawyer.ca. But that's for after. Right now, I'm here, Lior Samfiru, the employment lawyer, at your service, answering questions. Questions are coming in. It may be a busy session today, so don't wait till the end of the session to ask your question. Ask it right now, this very moment, so that I can get to it and you can get an answer. You can even ask a follow-up question if you want. So again, this is the employment law session. Let's talk. Let's ask or answer questions. All right. So Tanya asks, how long does it take to settle employment disputes with the Labor Relations Board? Well, employment disputes are not taken to the Labor Relations Board. Employment disputes should be taken through either the court or maybe a human rights tribunal. First of all, the Labor Relations Board is not where you would go. If you have a question or an issue with respect to overtime or vacation pay, you would go to the Ministry of Labor, not the Labor Relations Board. And those can be anywhere from a few weeks to a few months, but that's not the recommended course of action. If you have an employment issue with your former employer, existing employer, give me a call and we have to engage our legal process and we can resolve that very, very quickly. So it's not the Labor Relations Board. You'll never go to the Labor Relations Board unless you're complaining about a union. An employee is going to go to the Ministry of Labor. It's a different organization altogether. All right, good questions coming in. Let's answer them. A Google user is asking, are time limits to sign severance documents a myth? Well, it's not that they're a myth. They're there. You see them. So obviously they're not a myth. It's just that they're irrelevant. Your severance doesn't expire Friday on that deadline that your employer imposed there. In fact, your legal rights don't expire for 2 years, 2 whole years. So let's say you were let go on Wednesday and your employer says, we need you to sign the severance offer by Friday. No. Nothing happens on Friday. Do not sign it no matter what. That deadline is meaningless, okay? Here's how it works. Your employer is offering you a lot less than what you're owed, and they want you to sign this by Friday. How ridiculous is that? Let me give you an example. Let's say I owe you $1,000, but I say to you, tell you what, I'm only going to pay you $300, but you have to accept this by Friday. Well, you would look at me like I was crazy, right? Well, wait a second. You owe me $1,000. Why should I sign for you to pay me $300? Well, that's what happens with severance offers. Employers offer you a lot less, and they ask you to sign it by Friday or Tuesday or whatever the deadline is. So that deadline is irrelevant. It's meaningless. What you have to do is understand what you're owed and get what you're owed. In over 90% of cases, when the employer lets you go and they gives you that severance offer, it's a lot less than what you're actually owed. A lot less. Okay, that's where you call me to connect with me. Employmentlawyer.ca. Again, employmentlawyer.ca. So that's the answer. The pressure tactic. That's all it is. It's nothing. It's meaningless. All right. Next question from BGB1010. When on LTD, can one be laid off? Well, you cannot be laid off or let go because you're on LTD. Okay, that would be a human rights violation. You cannot be let go just because of that. Now, there are two circumstances where you could be let go when you're on long-term disability. Number one is if the termination had nothing at all to do with the disability. Let's say they shut down the whole department and they let go everyone in the department. Well, okay, I guess in that situation, if they let you go as well, it had nothing to do with your disability. That's going to be rare. The other situation is where you're on disability and you're not going to be able to come back to work at all. So your doctor's saying, that's it, you're done. You're not going to be able to come back to work. In that situation, that's what we call a frustration of contract. That means your employer can end the relationship with you. If you're in Ontario, they'd still have to pay you severance. If you're outside of Ontario, they won't have to, but that's how it works. But simply, you're on disability, you're working on getting better, and your employer lets you go. No, can't happen. Illegal. If that's what happens to you, you have to call me right away, immediately. And of course, to connect with me, you know how to do that. Employmentlawyer.ca. Okay, let's continue. Great questions. By the way, those joining us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. As you see, I'm here to answer questions. A bunch of questions have come in. More are coming in. You have time. You have plenty of time still. I'm here for another 25 minutes or so. So ask your question right now so I can get to it, answer it, and you can walk away with the information that you need. All right. N. Stinson has our next question. Does the federal government mandate for civil servants to return to auto offices means those workers are not entitled to severance if they do not wish to return? Yes, that's what it means. So if you're a civil servant and you were working in the office pre-COVID, then your employer is allowed to have you come back to work in the office now. Because COVID was a unique situation, and now that unique situation is over, or we're trying to move past it, your employer can have you come back to work. And if you don't, well, then they may consider you as resigned, or may let you go for cause because you refuse to come in. Either way, you would not be entitled to severance. Now, if there's a medical reason, maybe in the meantime, why you can't come into the office, they have to accommodate you as long as you have a doctor's note. If you were hired during COVID, okay, to work remotely, you never worked in the office, you were hired during COVID and you've always worked remotely, well, then they can't have you come back to the office because you were hired to work remotely. But if pre-COVID you're working in the office, they can have you come back to the office, and there would be no severance in a situation where the employee refuses. Great question today. Some terrific question. So Holly has our next question. I work a seasonal job where I work extra hours April through November and get paid the rest of the months of the year. After returning from maternity leave, my employer is asking me to make up hours. Not sure exactly what you mean. If they're asking you to work different hours now, well, they can't do that. If you refuse and they decide to let you go, number one, that could be a wrongful dismissal. Number two, it could be a breach of human rights code because of the maternity leave. It can be a breach of employment standards. So no, essentially what your employer is supposed to do coming back from maternity leave is take you back on the same basis that you were working before. So I'm not sure exactly what you mean about making up hours, but the bottom line is this. If they're asking you to do something different than what you were doing before your maternity leave, it's not legal, not at all. Can't do that, not even close. So if your situation is that, hopefully you know what to do. You call me, again, employmentlawyer.ca to connect with me, phone number, email, it's all there. Okay, again, employmentlawyer.ca to connect with me. But that's for after. Right now, I'm still live here. Questions, follow-up questions, new questions, they're all welcome. Tanya has another question for us on YouTube. She says, is it legal to keep changing job start times? So here's what I'm going to say about that. An employer doesn't have a right to make significant changes to your job start. But if they've been doing it for a while and you've kept accepting it, so yes, they kept changing, so I did what they asked, well, now they have a right to do it again and again and again because you let it happen the first once or twice. So if it's the first time, no, they don't have a right to make that change, perhaps. But if it's been happening for a while and up until now you were okay with it, then now they've gained that right because you let that happen the first time. That's why it's so important. And this is true for everything. If your employer makes changes to the terms of your employment, they change your hours, they change your pay, they change your shift, your responsibilities. The problem with accepting that is that by accepting it, you've given them the right to do it again. So your employer may not have had a right to do it that first time. That could have been a constructive dismissal. But by accepting it, by saying, you know what, I'm going to be the team player, I'm going to be the good soldier and accept it and continue working. As admirable as that is, by doing that, you've given them the right to do it again. So maybe right now they change your pay by 15%. You're not happy, but you continue working. By doing that, you've given them the right to change your pay again by 15, by 20, by 50%. So that's why whenever you're facing a change to the terms of employment, you want to take a step back and say, am I comfortable with this happening again and again? If you're not comfortable with that, you got to say, no, that's a constructive dismissal. Before you do that, before you ever say, that's it, constructive dismissal, you call me. No one quits, no one leaves, no one says the word constructive dismissal before you talk to me first, okay? employmentlawyer.ca to connect with me. Again, employmentlawyer.ca. All right, lots of questions today. So happy to see that, guys. I'm going to continue asking. Oh, I'm not going to ask, I'm going to answer. Holly on YouTube has the next question. Okay, she says, okay, so Holly was talking about coming back from parental leave. My employer is asking me to make up hours in the off season, despite other employees not being asked the same. So no, it's exactly what I said. You absolutely can say no to that. If you were let go because of that, yeah, there's going to be consequences to the employer. So no, they can't do that, Holly. Those joining us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. We operate in Alberta, in Ontario, and in British Columbia. So if you're in one of those three provinces, we got your back. We can answer your questions. We can help you. We can support you in any employment law issue. Peter has our next question. If you get fired, are you able to still get EI from previous hours from other jobs, or does the firing negate the opportunity to use EI? Well, you get EI if you lose your job, unless what you did is something terrible. So the only time you would not get EI is if the company had just cause to let you go. That means you did something so bad, so awful, that the company can't employ you anymore. So it's not enough to say, well, you were late, we're letting you go. No. That's not going to deprive you of EI. And by the way, you'd be owed severance as well. The only time you won't get EI or severance is if you did something bad. You stole, you hit someone, you committed fraud. If you did something like that, you're not going to get EI, and whatever happened with the previous job doesn't matter. But if that's not the case, even if the company says we have cause, the law makes that determination, not your employer. So Peter, if you lost your job, unless you did one of those awful things that I just said, you're owed severance and you're owed EI. So you need to call me, okay? employmentlawyer.ca, employmentlawyer.ca to get my contact information. You see that address on the screen? And that's exactly the way to do it, all right? So let's understand that it's very difficult to deprive you of EI and certainly to deprive you of severance. Tanya has a follow-up question. What steps to take if the employer retaliates after asking for reasonable accommodation and union doesn't assist? Tanya, so everything that we talk about only applies to non-union employees. If your union doesn't assist, you can file a complaint against your union with the labor board. But generally, you cannot deal with your employer. It has to be your union. So whenever you hear me talk about rights, constructive dismissal, severance, none of that applies to unionized employees. That's labor law. We're talking employment law, which is employees that are not unionized. Vanessa asks, I was initially given notice period of 2 months. Now that we're getting closer to the end date, I've been told this notice period is actually at a later date, not 3 months. Is this allowed? Well, it's allowed. What I mean by that is there's no law that says your employer can't extend your notice, but by extending it, it actually doesn't count. And here's what I mean. So if your employer says, we're going to give you 2-3 months, they extend it, well, they're going to want to rely on that notice to reduce your severance. Well, we don't have to pay you as much severance because you gave you all that notice. But because the end date kept changing, that notice may not count at all. So that's a good thing. Now, if you say, no, you said this month, so I'm leaving, then you've resigned. So you don't leave until your employer actually says your job is ended. But the good news is that they're going to have to pay you severance, and they're not going to be able potentially to rely on that notice to reduce your severance. So Vanessa, I want you to call me as soon as you know that that's it. The end of your job has come, and then I'll make sure you get your full severance. Your employer is going to try to rely on that notice. I'm telling you that they can't. All right? So very important. Lots of questions today. Love this. Guys, keep asking, and I will keep answering. Ashley on YouTube has our next question. I left the job for a new position. This company was trying to hire me for a year. After 2 months, the new manager said they're letting me go, but haven't given me an end date or anything. What should I do? Well, the first thing you do is you continue working until your employer says you're done. So they told you they're intending to let you go. Until that happens, you continue working. Because if you stop working, you're considered to have resigned. Okay, so very important not to do that. You're going to work until your employer says, that's it, it's your last day, goodbye. Until then, you're going to work, you're going to continue doing your job to the best of your ability as always. Now, when you are actually let go, you're going to be owed severance. But because you were recruited away from another job, okay, you're going to be owed enhanced severance that accounts for the time that you had with the previous company. So you may have only worked for this company for 2 months, but you're going to get paid as if you were there for longer to account for the fact that you were recruited away from another job. So you could be owed, depending on how long you worked with the previous company, you could be owed as much as 2 years severance, even though you only worked for 2 months. So that's the key here. You continue working, number one. Number two, as soon as you're done, you call me right away. No matter what they offer you, whether they offer you a day, a week, or 10-month severance, you call me right away. And to connect with me, of course, employmentlawyer.ca. Again, employmentlawyer.ca. Now, this is a good opportunity to tell you, how do you find out yourself how much severance you are owed? If you want to know right now, you don't want to wait till later, you don't want to even call me, you just want to find out now how much severance you're owed, you can do that in seconds. Grab your smartphone, your tablet, your desktop, whatever you want, and go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. Why do you go there? Well, you go there because we have our severance calculator tool. Been used by over 2 million people so far. Our severance calculator tool allows you to find out in seconds how much severance you're owed, whether it's a month or 24 months or anything in between. It's completely free. It's completely anonymous. No names, no phone numbers. It's just there for your benefit. Easy to use and takes seconds. So pocketemploymentlawyer.ca, always the first place you go to. If you've just lost your job and you're staring at that severance letter, if you're worried about losing your job, if you're curious, whatever the circumstances, pocketemploymentlawyer.ca and use our severance calculator. All right. Next question comes to us from Pedro on YouTube. Pedro says, I was accused of sexual harassment and was placed on unpaid suspension by my employer. Found I was not at fault, but then also had a performance improvement plan as a backup to start paper trail on me. So number one, the unpaid suspension is illegal, okay? You cannot be put on an employer doesn't have a right, unless you're part of a union, your employer does not have a right to put you on an unpaid suspension. So that's number one. Number two is if you're being put on a performance improvement plan and you don't agree with it, you have to say so in writing. Write an email to your employer saying, here's why I don't agree with it. Here's, you said I did these things. Here's why that's not accurate. Here's the real facts. By doing that, you're going to make it very, very difficult for the company to let you go, certainly to let you go for cause. And depending on how long you were on an unpaid suspension, that could also be a constructive dismissal. So Pedro, if you want to connect with me and discuss this in more detail, easy to do. Just go to employmentlawyer.ca. That address is on the screen right now, employmentlawyer.ca. Phone numbers there, email addresses there. Forms are there if you want to fill out a form. It's all there for you to connect with myself and my team. But right now, guys, I'm still here live. We still have a bit of time to answer questions or to ask questions. I'm an employment lawyer, Lior Samfiru with Samfiru Tumarkin LLP, live here answering your questions. All right. MZMLE on YouTube. For refusing the vaccine, have to go to court to win severance pay. All right. Hopefully, I'm still connected. 99% of matters resolved way before you go to court. Way before. Okay? So, no, you don't have to worry about going to court. Now, in 1% of cases, you have to, but we've been settling these cases, resolving them every single day. We've resolved hundreds, if not thousands already, cases across Canada where we got severance for our employees, or our clients, I should say, that were employees. So if you've been let go, or you've been put on an unpaid suspension, you haven't paid your severance, call us. Let's resolve this now. You don't have to go to court. We can get this done as soon as possible. So connect with me as soon as possible, of course, employmentlawyer.ca. All right, Teresa has our next question on YouTube. Teresa says, am I able to get unemployment benefits if I was let go for not taking the mandated COVID-19 vaccine? Well, likely if you simply apply for that, you're probably going to get rejected. But here's how we get it. Number one, we can get you severance. And when we deal with your employer, we'll get them to issue you a new revised record of employment that would allow you to qualify for severance. But if you have your current record of employment, you will likely get rejected. So severance is owed to you. Again, this all assumes you're not part of a union. Severance is owed to you. And when we negotiate severance, we'll negotiate a new record of employment. So yes, you can get EI, but we just need to get involved and do some work to get you that and to get you severance. So Teresa, you know what to do. Reach out to my team and I at employmentlawyer.ca. Again, employmentlawyer.ca. Pedro asks a follow-up. Let's see. Okay, Pedro, who was accused of sexual harassment and was put on an unpaid leave, he says, I was also fired and my employer hasn't replied to unemployment after the 30-day time frame. Okay, so you said that they're putting you on a performance improvement plan. So I'm not sure what you mean you were also fired. If you were fired, the issue is not unemployment. The issue is severance, okay? EI is going to do what they do, but you need to get severance. And in fact, you may get so much severance you wouldn't even qualify for EI. You get a lot more than EI. So Pedro, you need to contact me as soon as possible, okay? And I think you just said it's been since November 29th. I was terminated. My employer also hasn't paid me my PTO upon termination. Okay, no, you shouldn't write a letter or you shouldn't call them. You're not going to accomplish anything. Pedro, I've been saying this the whole session. You got to call me, okay? You got to let me and my team do what we do. It's much bigger than just the EI. You could be owed 2 years severance. And depending on the situation, you could be owed other damages as well. So you need to contact me as soon as possible. Again, employmentlawyer.ca. All right. I think I'm caught up on questions right now. Let's see. Oh, MZMLE had a follow-up here. Is the pocket employment lawyer calculator based on full-time hours only? So no, it applies to all employees. Doesn't matter if you work 5 hours a week or 50 hours a week, it applies to you just the same. The number of months that you're owed. Now, if you earn a little bit of money, then 2 months for you is less than someone that earns a lot of money, but you're still owed 2 months. So it doesn't matter if you're full-time, part-time, if you're in a junior, senior position, it works just the same. Pocketemploymentlawyer.ca, our severance calculator, the best tool to go to if you lost your job. Always. 90% of the time, over 90% of the time, what you've been offered is a small fraction of what you're actually owed. Small fraction. Okay. Ashley has a question on YouTube. She says, what are the laws in regards to drug testing for jobs in Ontario? So great question. Generally speaking, drug testing is not allowed, okay, not legal, except for, number one, if it's an extremely security sensitive position, if you're working with equipment that could kill someone, and we can have any form of impairment, there's a small window to do drug testing. The other situation is if you're working in a workplace where they've had problems in the past, or you've had issues in the past where you've been under the influence, then maybe there's a bit more leeway. But those are very small exceptions. In most cases, drug testing is not legal. It's not allowed, drug or alcohol testing. But again, if it's a very safety sensitive position, there may be some leeway there. But also, just because someone is under the influence of drug or alcohol doesn't necessarily mean they can be fired. The law recognizes that drug dependency or alcohol dependency could be considered a disability. So that may mean the employer has to accommodate, maybe to let you take time off to get better and get healthy. You can't just be fired for it. But in most cases, drug testing in the workplace is not legal. The other thing that I want to make sure that you understand that's illegal is you can never be let go for discriminatory reasons. And what I mean by that is you cannot be let go because of your age or your ethnicity or your sexual orientation, etc. That is completely illegal. That's discrimination, and that's not allowed. Even if that discriminatory reason is not the only reason you were let go, it's just part of the reason. It's one of several reasons. It's still illegal. It can't be even a factor. So your age, as an example, cannot be a factor in deciding to let you go. It's illegal. Now, in most cases, and you've heard me say this before, an employer can let you go for pretty much any reason as long as they pay you severance. But there's exceptions to that. And the exception is discrimination. You cannot be let go for discriminatory reason if even if severance is paid. Never. It's illegal. Pedro just said, I'm in Washington State. Would that make a difference? So Pedro, unfortunately, you've been wasting your time here. Nothing that I said today applies in Washington State or in the United States at all. We're strictly in Canada. This is a Canadian session. So I have no idea about the knowledge of Washington State, and nothing at all that I said should be seen as applying anywhere in the United States. If you're in Ontario, in British Columbia, in Alberta, you can take what I said to the bank. It applies to you. In Washington State, I have no idea what the law is. This session is not for you at all. Okay? If you have any last minute question, guys, now is the time to answer it. I've been talking about when it's not legal to let you go even if severance is paid. And I gave you the example, discrimination. You cannot be let go for discriminatory reasons. Another time where you cannot be let go even if severance is paid is if you're complaining about workplace harassment. So we all have a right to work on a harassment-free work environment, all of us, right? So that means that you also have a right to advocate for yourself and to talk to your employer, to tell them to investigate and to deal with that harassment. And they have to, by law, do it. What they cannot do ever is penalize you, let you go, punish you in any way because you complained about harassment. That's completely illegal. Can't do that. We call that reprisal. That could be a violation of at least 3 statutes. So if you're complaining about harassment and your employer is not taking it seriously, not investigating, not solving the problem, God forbid they're punishing you because of that. If any of that happens, you call me right away. Again, employmentlawyer.ca. All right, I'll take one last question from JGB1010. After COVID, the employer brought people back to the office 50% of the time. Can they now extend it to full-time in office? Yes. So if pre-COVID you were working in the office 100%, they can make you go back to the way you were working pre-COVID. Now, if you were hired during COVID, they can't do that. If you were always at home even pre-COVID, they cannot extend it. But if you were working in the office pre-COVID, they can say, now we're going to go back to the way things were pre-COVID, even if that means working 100% in the office. So very important to remember that. Guys, that's the time that we have for today. Lots of questions today. One of the best sessions that I can remember in recent weeks. So thank you for that. You always make the session that much better. I'm glad I had the opportunity to answer those questions today. Again, I'm Lior Samfiru, the employment lawyer. I'll be back next week, but we do these sessions often. So go to our website, employmentlawyer.ca, to find out when the next session is. But better yet, if you have an issue, don't wait till the next session. Contact me in the office, okay? employmentlawyer.ca to do that. Phone number, email, it's all there. So looking forward to connecting with you then. Guys, thank you very much. Have a great rest of your day, and we'll talk soon.